So good morning, everyone, and thank you for accepting our invitation. My name is Christine, and I work within the policy team at the Malta Business Bureau. This is an informative webinar that focuses on the proposed Data Act. We have a varied audience from different businesses. We are still getting a few people who are joining us now, and we will be introducing our speakers in a moment. In the meantime, I'm going to remind everyone of a few housekeeping points. You are kindly asked to keep your microphone on mute. You can choose to switch on your camera on or off as you wish. The session is being recorded, and participants are welcome to include comments and questions in the chat section, and we will open the discussion towards the end of this webinar. Once we are at the Q&A portion, participants can either write down their questions or raise their hand to ask their speakers their questions. I have included the MBB email address in the chat, which you can view. You can contact us after this meeting with any questions you might have. You can also reply to the email address that you have already received with the details for this webinar. So without further ado, for our agenda today, we are starting off with an opening note from the Malta Business Bureau's President, Ms. Alison Mizzi, followed by CEO of the Malta Chamber Enterprise and Industry, Dr. Marthese Protelli, who has just joined us, and who will be giving her comments on the Data Act from a local business perspective. Ms. Maria Rosaria Coduti from DG Communications, Networks, Content and Technology at the European Commission will give us an overview of the Data Act and what it entails. And Dr. Paul Mikalev-Grimont from Gonado Advocates will present to us some notes on the Data Act from a more legal perspective. We will finish off our webinar, as I've already discussed, with the Q&A portion. So we can start with today's agenda. Ms. Mizzi, thank you for joining us. The floor is yours. Sorry, we can't hear you.
Apologies, I was muted. Thank you, Christine, for this introduction, and thank you all for joining us this morning for this webinar where we will be discussing the new Data Act. This webinar, as Christine said, is being organized by the Malta Business Bureau, which organization, as you might already be aware, is an organization that represents the Malta Chamber and the Malta Hotels and Restaurants Association in relation to EU matters. It has an office in Malta and in Brussels, and one of the main tasks of this organization is to provide information to the Maltese business community with regards to EU policy and legislation in relation that can impact in some way or another their operations. And in fact, one of the EU policy that we're following is the EU Data Act, which we are presenting to you today to give you information on what is happening with this new act. So why are we focusing on data? As you are aware, data has become more than ever important in our everyday lives. It is having a direct impact on the personal way of living as well as within the business dynamics. There are sheer volumes of data that is being generated by humans and machines in our daily living, and it is recognized that this data has the potential to create new business opportunities by generating value through data that is data-driven through innovation. And it also presents an opportunity to create new solutions, which can improve our quality of life by helping us make better informed decisions through the identification of trends and consequently the ability to make projections. So there are several advantages that can be gained from the harnessing of different uses of data. And the EU's vision is to facilitate data access as much as possible by removing barriers within the context of the European laws and value, so that everyone can tap into the benefit that this data can provide. And all this mission to facilitate access to data triggers the need to regulate, which is founded on three primary reasons. Firstly, we have the need to unlock the value of data. We need to clarify who can create value from such data and under which conditions. And number three, we need to definitely ensure fairness in the allocation of data value among the actors of the data economy, whilst also respecting the legitimate interests of the parties involved. And all these needs have brought about the need to have an act. And this is what we're presenting to you today. This Data Act, which stems from the European Data Strategy. So the idea here is to have a data-driven society, which leads to the creation of a single market for data. This free flow of data is obviously expected to benefit businesses, researchers, and public administration, and specifically within the business context. What we are seeing is that a facilitated data access is one of the pathways in achieving business resilience. As in this way, businesses will be encouraged to innovate and grow because they can rely on secure and dynamic data. As you may appreciate, the facilitation and access of data comes with its own challenges, and subsequently, clear rules are definitely necessary. So these new rules also, within another context, present an opportunity to customers and companies who are being empowered to have the say of what can be done with the data that is being generated. So the Data Act that we will hear about today is primarily concerned, the general objective is about access of data, and the idea is to focus on achieving cheaper prices for aftermarket services, better access for such data, and the creation of new opportunities for data use. And what is important today is that we continue to understand what is happening with this proposal, how this is being how this can affect us locally, and thirdly, how greater accessibility to data can lead to added value that supports the EU's twin transition of a digital and green Europe. I thank you once again for attending today's webinar and wish you a fruitful discussion. And I really encourage you to actively participate by presenting us your comments, concerns, and expectations. Thank you very much. And I pass on the floor back to Christine.
Thank you, Ms. Mizzi, for your introductory remarks, which do put us in the picture. Dr. Portelli, may I now invite you to share with us the Malta Chamber's reaction to this act? Dr. Portelli, your microphone, please.
Good morning, everyone. I've just joined you from the Malta Affairs and Conference Center because this morning in Malta we are seeing the launch of the pre-budget document. So basically I'm going to share my point of view from over here. We consider this webinar as being a very important step forward, particularly more so because for the Malta Chamber of Commerce, Enterprise and Industry, data is considered as the new oil. And I'm going to start off by mentioning some statistics which continue to prove the importance of legislating in the right way. So as we all know, the volume of data is constantly growing. In 2018, we generated 33 zettabytes, and by 2025, that is calculated to go up to 175 zettabytes. So we are seeing a big growth when comparing 2018 to what we are anticipating will happen in 2025. Also, we've looked into data that is collected and used by industry, and it results that in around 80% of industrial data is never used. So it is very, very important that we keep advocating in favor of the use of data and the proper use of data. And this is in fact also the reason why we consider that this act to be a beneficial one. First of all, because it intends to make better use of existing data, but at the same time, it also provides for safeguards against misuse of this same data. It's also important to ensure that we have a fair system that ensures that data can be shared, what data can be shared, with whom it can be shared, and on what basis that should be shared. So ultimately, and I will stop here because I would prefer to pass on to Dr. Paul Micallef-Grimaud, who is an expert in this area and who will explain all the nitty-gritties of the law. The ultimate scope of the law itself should always be one which stimulates a competitive data market with open opportunities for data-driven innovation, whilst also protecting innovative manufacturers.
Thank you, Dr. Portelli, for your remarks and for joining this webinar today on the move. Ms. Koduti, thank you for accepting our invitation. The floor is yours in giving us an overview to our audience on the proposed Data Act.
Hi, good morning, everyone. Can you hear me, first of all?
Yes, we can, very clearly.
And can you also see my slides?
Yes, we can.
Okay. Thank you very much for having me here. I'm Maria Rosaria Koduti, and I work as a policy officer in the Data Policy Innovation Unit of DG Connect, and when we are based in Luxembourg. I really have to thank my previous colleagues, Alison and Marthese, because they have already said the fundamentals. They have already laid down the background upon which we at the Commission have built the data strategy, and to make sure that more and more data is used for the benefit of the economy of the society. Indeed, again, as you can see in my slide, I wanted indeed start from the highlighting that Europe are really everything to play for, and we have already heard the transformative, revolutionary power of data that can have a meaningfully impact in all the sectors of the economy, but can also help improving the delivery of public services. Personal and non-personal data are a source of innovation or products and for product services, and data can really make our lives and work easier and better, as had been clearly shown by the pandemic, where thanks to data and technologies based on data, we were able to keep on basically with our lives, to work, to learn, and to cure and treat ourselves. And then indeed, as my previous as the previous speaker was highlighting, we are really experiencing a huge expansion of the production of data from the 33 zettabytes to the 175, and we really have to tap into this potential and make sure that also non-personal data, industrial data, the data that is produced by the new Internet of Things object is really harnessed, is really exploited to benefit society and economy, and Europe has to make sure that it happened to harness this second wave of data, the industrial data. So we need to act because we need to find an alternative model to the current business models around data, focused on big tech and all the things we know already. And we have also to act because the development of data economy in Europe is, let's say, put on hold by high transaction costs of data sharing. The fact that even if data is already out there, is produced, is stored somewhere, but it is not available for reuse. So data is trapped in silos. And we also observed an increasing regulatory fragmentation. So if we want to really build a single European market for data, open and sovereign, we need to address these issues. And we try to build the foundation for this work in the European data strategy that we published in February 2020. That is, of course, built on the full respect of EU rules and values and existing legislation on data. First of all, the General Data Protection Regulation and the Free Flow of Data regulation as well. So in the data strategy, we lay down both legislative policy measures to build the regulatory framework for more data access and use in Europe, but we also have some provide some funding to make sure that also the technical enablers and infrastructures for more data access, share and use in Europe are developed. So the data strategy is built on these 4 pillars: a cross-sectoral governance framework for data access and use, the enablers, investment in data spaces and federated cloud infrastructures, competencies, because we really need also to invest in digital skills, digital literacy. We have to empower digital workers all around the 27 member states. And we also have to make sure that both government and industries go on the path of digitalization at the same speed. And then a very important part of all this project is the rollout of common European data spaces in some sectors of the economies and domains of public interest. The data strategy announced the creation of 10 data spaces, and actually some new ones have already been added to the list. For example, the language one. And the data spaces will be crucial because when they are set up and they are interoperable between themselves, they can talk, let's say, to each other. We will really see data that is used and shared in the data spaces and between the data spaces to benefit the economy and society. So the cross-sectoral legislation to enable the data strategy is based on these legislative proposals and acts that you see in my slide. So on one side, we go towards openness of the data that is already there. With implementing act of high value data sets, for example, and data governance act, we want to make sure that voluntary data sharing is boosted, and then data that is already collected by the public sector is made available for reuse. And then on the other side of the spectrum, we have the Data Act and the Digital Market Act that help us to also correct market imbalances in the data economy. And as I was mentioning before, it's essential that to keep in mind that these new legislative proposal, they are totally compliant with the GDPR, and given that we know that one size approach cannot really fit all the sectors, we also leave the possibility for sectoral legislation to satisfy better the needs of the specific sectors that cannot be included that are not included in the horizontal overarching framework. So now moving towards the Data Act specifically, with the proposal for a Data Act, we really wanted to bring legal clarity and regulate who can use what data and under which conditions. Because the aim is to ensure fairness in the allocation of data values, to make more data available while safeguarding incentives for data generation. We want to unlock the value of Europe's industrial data. And we want to help the EU to become a global leader in the data economy, because with the data strategy, we built a governance model for data that we think can be also projected outside the European border, and we are welcome, we welcome to work with third like-minded countries that want to start a path based on for the data economy, based on the sharing of our values. So the Data Act starts from the understanding that there is a new value in data, and everyone would like to capture this whole value. And it is important to sort out who gets the value, because otherwise data will just simply be less used, which is a problem. And this is particularly the case of IoT objects. And if we think about all kinds of smart objects in our households, from the smart solar panels, smart dishwashers, cleaning robots, etc., or smart objects that are used in industry, factory robots, harvesting machines, building equipment, these are all new technology that produce lots of data. So things used to be simple in the past, but how does that work for object generating data? Do they belong to the manufacturer of the objects, to the user, or to third parties who have an interest? Things are simply not clear. So some chapters of the Data Act are dedicated explicitly to try to resolve these issues. Then we also want to tackle a contractual unfairness and make sure that also SMEs can act in a level playing field in the data economy. Then we want to make data that is held by businesses available in some specific circumstances to public sector bodies and EU institutions for the common good. And we also want to easier switching between cloud service providers. And of course, without facilitating data flows through technical standards and interoperability, then data cannot be accessed, shared, and used. So the Data Act also addresses these topics. In what the Data Act proposes in terms of business to business and business to consumer data sharing. Let's be clear in saying that the Data Act in this context regulates economic rights on data and further empower consumers in the data economy, because more actors will be able to innovate thanks to the wider access to data, especially in the context of IoT. What we can see in this slide is that with the Data Act, we are creating possibilities for the users of a connected objects, that includes both individuals and companies, businesses, to get access to the data or to give it that they contribute to produce by using it interactive with connected objects. But we also give them the right to give this data to third parties, for example, for aftermarket services. At the same time, the manufacturers keeps the possibility to use the data and to protect the data where necessary. In case there are trade secrets involved, the data holder in these slides is the manufacturer, and the user can agree measures to preserve the confidentiality of the data, in particular in relation to transfer of data to third parties. And both user and third parties will have to respect the prohibition for the third party to develop a product that competes with the product from which the data originated. And this serves as a safeguard for the manufacturer. It places a limit on the data recipient or user regarding the use of data received on the basis of the new access rights, because we don't want that the third party is able to reverse engineer the product or produce a copycat, because the Data Act is about fostering innovation by developing new services. And the Data Act is a real SMEs instrument, because as we can see in these slides, we make sure that companies are prohibited from unilaterally imposing unfair contractual clauses related to data sharing on SMEs. So the Data Act in the B2B context also introduced an unfairness test through which it can be accessed if contractual terms imposed on micro, small, or medium-sized enterprises are unfair, and in this case they are not binding. And of course, in the Data Act, you will find a list of criteria to assess this. Then, of course, another very important and also a bit revolutionary chapter of the Data Act is the one regulating, creating a mechanisms to make sure that when there is an exceptional need for data, the public sector body or the EU institution, like the Commission, for example, can ask the private sector to provide it with this data. I think it's pretty clear that for example, by looking at the example of the pandemic, that we need a governance framework to allow the public sector to access and use certain data from companies, and this is also about companies getting multiple requests for the same data and the need of streamlined procedure. And this was also confirmed by a report that an expert group on business to government data sharing released in 2020. So with the Data Act, we harmonize at the European level the business to government data sharing by providing clear rules on how requests for data should be made in this context. And we define the conditions pretty clearly under which the mechanism can be activated. It is a limited and targeted mechanism for cases where the public sector bodies cannot get the data through normal means. For example, through reporting obligation, or by buying the data on the market, or by procuring the data. So the exception, the concept of exceptional need is crucial to understand this chapter of the Data Act. And then we also say that in case of emergencies like a pandemic or like a natural disaster, when the government has to provide services, to save lives immediately, then no compensation is foreseen. In all the other cases, when there is exceptional need, for example, when a public sector body has to fulfill a public task that has been explicitly assigned to it by law, then in that case, the companies can ask for a contribution for some compensation, and the Data Act clarify the level of this compensation. About cloud services, the Data Act also has provision to improving trust and performance of data processing services and interoperability and standards, because providers of data processing services must prevent unlawful data access and transfer based on requests from third countries. The Data Act laid down minimum requirements to ensure easier switching between providers of data processing services for customers. And the Data Act will also increase interoperability by facilitating the development of common specifications to address the lack of harmonized standard and technical specification. So concretely, what is the Data Act going to change? The Data Act is going to unlock the potential of the European industrial data, so will create new database businesses opportunities. It has a strong empowering component because we need empowering individuals and consumer and companies that use connected product and related services. And we will boost more transparency and control, as well as better decision on data. The Data Act will improve public service delivery, including response to effective public emergencies, because thanks to the Data Act, the public sector body will be able to provide better and more efficient public services and policies. And then the Data Act will allow the switching for cloud users. Multi-vendor, interoperable, and federated cloud edge service market will be facilitated. Sorry. So to conclude, we can all agree that data innovation creates huge, great opportunities, but also challenges. The organizations, the businesses that will cope with this new wave of data will be the future champions, because they will be able to capitalize on that to provide better product and services. And we, of course, it is clear that European level actions is needed to really boost the development of the European data economy and avoid fragmentation in the Union. And with all the actions that we are putting forward in the data strategy, we are expressing our commitment to support and improve European data-driven competitiveness and trying to create a level playing field for economic actors that also have to interface themselves with the international arena. So thank you very much. That was my introduction on the Data Act. Thank you.
Thank you, Ms. Colucci, and thank you for accepting our invitation today. This was a very insightful overview on the Data Act. The information gives our audience today a good background on the act that we are discussing. Now I would like to introduce our last speaker for today, Dr. Micallef Grimaud from Ganado Advocates, in giving us further insight into this Data Act from a legal perspective. My colleague will now share the presentation, and please just indicate whenever we need to change the slides. Thank you.
Thank you, Christina. Good morning, everyone. I'll be attempting to go through the main provisions of the current draft that we have available. As far as I'm aware, this draft, in fact, it's not a final draft yet of the Act. Up till yesterday, it was being discussed. A further draft was being discussed at the telecom sector group, and we'd expect that over the coming weeks and months, the drafts will continue to be rehashed. But it's evident that we are zeroing in now on details rather than the main principles and the main provisions themselves. So if we start with the first slide, next slide, the objectives. Taking from the explanatory memorandum to the act, to the current act that we've got, as we've heard also before, the main aim of this piece of legislation is to provide opportunities for the reuse of data, ensuring greater balance in the distribution of the value from data. And it is seen that regulating data access and use is therefore a must in order to lead to this final aim. If we look back at the European Parliament's resolution, which listed basically the aspects that needed to be tackled by this piece of legislation, the Parliament had indicated the need to encourage and enable greater and fairer flow of data in all sectors, from business to business, business to government, government to business, and government to government. And also to address imbalances arising from the concentration of data that restrict competition, increase market entry barriers, and diminish wider data access and use. And as we've already heard, in fact, this piece of legislation is one of the various pieces of legislation that interplay to try and achieve a more balanced playing field. I must say from the outset that when we'll be looking at the provisions themselves, one feels a bit of somewhat hesitation as to how far could the Act go in allowing for full competitive ease out. Also, the European Parliament had indicated the need to guarantee adequate access to data for SMEs, and as we will see, SMEs are in fact quite protected by and at the center of this piece of legislation. So next slide. In the words of the Commission puts forward the proposed Data Act with the aim of ensuring fairness in the allocation of value from data among actors in the data economy, and to foster access to and the use of data. And it does this in a number of ways. So let's move straight on to the next slide, which basically asks the question, how will the objectives be achieved? So The first milestone reached by this act is that from now onwards, when the act is actually implemented, manufacturers of connected products and providers of related services, which are known as the data holders, can only make use of non-personal data of users if contractual terms are agreed to with users. So unless there are contractual terms regulating the use of this data with the users, the data holders cannot make use of data generated by the connected products. I refer to non-personal data because, as we've already heard, personal data, which is already regulated by the GDPR, was already there are already currently in place the necessary obligations to allow for the use and processing of personal data in given circumstances and subject to the conditions and obligations in the GDPR themselves. So here we are speaking of all forms of data and not merely personal data. There is one major derogation to this first milestone that I've just mentioned, which is basically provision of access to public sector bodies and union institutions, agencies, or bodies on an exceptional need basis. The basis and how public sector bodies and institutions could request data holders to provide them with data is clearly regulated in the Data Act, but up to the last draft, which was being discussed even yesterday, there is some fine-tuning as to what should constitute exceptional need and in which circumstances could compensation be requested by the data holders to the public sector bodies and the union institutions requesting the data. Contractual terms, this is another fundamental point that, and principle that we meet in this Data Act. Contractual terms that are unfair and unilaterally imposed on microenterprises or SMEs shall not be binding. And therefore, this is an indication of how SMEs and microenterprises are actually being protected by the Data Act. And the Act itself also stipulates what is an unfair contract term. There are three, which basically are terms which exclude or limit the liability of the manufacturer for intentional acts or gross negligence, terms which exclude the remedies available to the users in case of non-performance of contractual obligations, and terms which give the manufacturer the exclusive right to determine whether the data supplied are in conformity with the contract or the right to interpret any term of the contract. So those terms of that nature are immediately deemed to be unfair. Then there are also terms which are presumed to be unfair, but of course, because it is a presumption, one would need to prove that it is not the case that the term is unfair. And there is a list also of these presumed unfair terms, which I will not go into because we are pressed for time. One important, and this is what I was referring to earlier, also an indication of the hesitation as to how far could the Data Act go in promoting competition through data use. Is this prohibition that basically one cannot it's not this, it's coming later. This is another prohibition. It's important to note the fact that this prohibited use clause is that holders of data cannot use data to derive insights about the economic situation, assets, and production methods of the user or any other use that could undermine the commercial position of the user in the markets in which the user is active. So if we go to the next slide. Linked to the first, therefore, principle, which is the use that could only be made through an agreement with the user, is a transparency obligation whereby manufacturers are also bound to provide certain pre-contractual information prior to concluding a contract, which would include the nature and volume of data likely to be generated by the use of the product related or related service, how the user can access the data, how the user can contact the data holder quickly and communicate with the data holder efficiently, and whether the data is generated continuously or in real time. Next slide. The second main principle is the access by design principle. So here, the manufacturers of connected products and providers of related services are obliged to make data generated through the use of the products or the services available by default to the user in an easy, secure, and directly accessible manner. So we're in the data protection and the GDPR context, we are familiar with data protection by design principle. And in this context of the Data Act, we're speaking of access by design. Therefore, the user must be given accessibility of the data through the use of the product itself. But where this is not feasible, and therefore the user cannot access data directly from the product, the data holder must make available to the user upon simple demand the data generated by the user without undue delay, free of charge, and where applicable continuously and in real time. There's an exemption here on micro or small enterprises where these are the data holders, and therefore these are the manufacturers of the connected products or providers of the related services, where they do not need to abide by this access obligation. Further exemptions, and this is what I was referring to earlier on in sort of the strain as to how far the Data Act goes in promoting competition, is the second exemption listed, that where the intended use to be made of the data being requested is to compete, in fact, with the producer, the manufacturer of the connected product, then the manufacturer of the connected product is exempt from providing the data. And this obviously, especially when we're speaking of, we're coming to it in the next slides, of the sharing of data with third parties, this in itself creates a restraint on the benefits that can be achieved through this Data Act. Another exemption is where the data being requested may constitute a trade secret of the manufacturer of the product. It's again, even here, it is somewhat difficult to understand how the data itself could in itself be constitute a trade secret. And I say this because the recital 17 to the Act makes it very clear that the access that could be requested and must be provided by the manufacturer of the product is not derivative data, that is data which the manufacturer derives through the use of software, but the actual raw data which the manufacturer is collecting at the point of use being made by the user. And therefore, it's somewhat difficult to understand how this raw data in itself could constitute a trade secret for the manufacturer of the connected product. Again, there's in line with GDPR, personal data obligations and GDPR obligations must be respected when providing access to data. Next slide. We come to the third-party sharing, which is basically another fundamental point of this Data Act, which is the user's right to request the holder to provide access to the user's data to third parties. Therefore, not only the user himself or itself can request access to the data, but it could actually request the holder to provide this data to third parties. Access to third parties is to be provided free to the user, not to the third party. And what we mean here is that the holder of the data may impose consideration obligations on the third party, although the Data Act stipulates that the compensation charged must be reasonable, and in respect of SMEs or micro enterprises, these shall only pay for the costs incurred by the holder in performing the transfer of the data, so the transfer operation. In case where disputes arise, even on basis of compensation, there is a dispute settlement procedure thought of in the Act itself. And the access to third parties must be provided without delay in the same quality as available to the holder, and where applicable also continuously and in real time, and on fair non-discriminatory terms to be agreed with the recipients of the data. Gatekeepers, and therefore those that are defined as gatekeepers in the Digital Markets Act, and these would typically be operating systems, are not eligible third parties to actually make use of this third-party sharing obligation. The holder shall not make use of the data to gain insights about the economic situation, assets, and production methods of or used by the third party that could undermine the commercial position of the third party. And also the exemptions that we mentioned earlier arise. Therefore, micro small enterprises are not obliged to abide by this obligation. Personal data and trade secrets, as mentioned above, need to be respected. There's also a note to be made here that the sui generis rights in the database directive cannot be claimed as an exemption to this obligation, and therefore the sui generis rights arising from the database directive are actually disapplied both to this third-party sharing obligation and also the access by design obligation we saw earlier. And the third-party recipient also has obligations, including not to pass on the data made available to him to third parties, and not to use the data to compete with the holder. I'm going to run through the next few slides, which is basically switching cloud service providers. Here, this is also another fundamental principle in the Data Act, which basically allows for methods whereby one could switch from cloud service providers within a 30 calendar day period from notice being given, during which the cloud service provider must continue to provide the service and do everything necessary to allow for the switch to take place, and must remove obstacles to entering into new agreements with other cloud providers. It must remove obstacles in relation to the porting of data, and also obstacles to maintaining functional equivalence of the service in the IT environment of the new provider. Additionally, contracts concluded with data processing service providers must now set out the parties' rights and obligations in relation to switching between different providers. So even over here, we've got the transparency obligation. As to the last slide, there are also obligations similar to what we see in GDPR to make sure that third country transfers do not breach EU law or member state law, and therefore cloud service providers should not allow for data transfers outside of the EU if this would breach EU law or member state law. In this regard, we are expected to see guidelines from the European Data Innovation Board. And similarly, we are also expected to see certain standards being developed with respect to interoperability of cloud services in order to allow for proper interoperability of the interoperability obligations to be performed properly. And finally, it is also good to mention that the Act lays down essential requirements for smart contracts for data sharing, which include the need of robustness, safe termination and interruption, data archiving and continuity, and access control obligations. This is literally a snapshot of the main provisions of the Act. I thank you for your attention. Of course, if you have any questions, feel free to pose them either now or even afterwards. And I'm sure that you will be they will be passed on to us, and we'll be happy to answer them.
Okay, thank you very much for this insight. I am sure that such detail has helped our audience better understand the technicalities of this Act. We are now at the end of our presentation, so we are moving on to the questions and answers section. So there are a few minutes left, and we would like to open the floor to our audience. Just a reminder to either raise your hand or write the questions in the chat. And please, when speaking, do state your name and who you are representing to our speakers. So are there any questions? Yes, please go ahead.
Hi, I'm Brian Ogden from Ninja Mobile Limited. My question is regarding enforcement. Just for some background, Facebook did some recent activity in terms of negotiating surrounding infractions, which revealed that there's not just one Cambridge Analytica, who incidentally was backed by a black ops security firm, that there are dozens of, if not, 50s or hundreds of Cambridge Analyticas that have been operating. This act seems to be addressing this kind of unfair competitive environment and helping to support SMEs to address these sorts of infractions and this corruption. What enforcement activity is going to surround these policy changes? What funding is available and training is available so that these policies will actually be enforced?
Thank you for your question. Ms. Koduti or Dr. Mukallaf-Grimo, would you like to answer this question?
Yeah, maybe I can start. But I'm giving you the perspective of the Data Act, and its Chapter 9 is about implementation and enforcement of the Act. Of course, having clear responsibilities is essential to make this proposal work. And member states will designate competent authorities for the enforcement of the Data Act, and individuals and companies will be able to lodge complaints to those authorities. And of course, if you all the details of these are contained in Article 31 and 32 of the Data Act proposals, and then Article 33 establish penalties, because member states will have to lay down rules on penalties applicable to infringements of the Data Act regulation, and shall take all measures necessary to ensure that they are implemented. And the penalties provided for shall be effective, proportionate, and dissuasive. Member states shall, by the date of application of the Data Act, notify the Commission of those rules and measures, and etc. So, of course, what I can say now, I'm trying to say here, is that in the Data Act we also build, the enforcement mechanism to make sure that when the proposal becomes regulation, it is clear how the legislation will be implemented and which authorities are responsible for the enforcement of the provision of the Data Act.
Thank you. Does that answer your question? So would there be any other questions? Yes, there's one in the chat. Michael, would you like to read it out to our speakers, or shall I?
Sure, it's fine. Sorry about that.
That's all right.
So basically, Dr. Mukallaf-Grimo, maybe because it's more of a legal question, it's something you've already tackled. So do you think that this new regulation will create a new officer within companies, sort of like the GDPR did with the DPO? And if not, do you think that this new form of compliance or regulatory requirement can be allocated to already existing members within larger firms who handle this kind of data, such as a security officer or a confidentiality officer? And secondly, because this is going to be implemented in the form of regulation, do you maybe foresee any issues regarding elements of a contract or pre-contractual liability, which you mentioned earlier? Thank you.
Hi, Michael. Well, in terms of GDPR, as you are very well aware, there's an obligation to have a DPO in certain instances, because, admittedly, the GDPR is much more laborious in terms of the obligations that need to be fulfilled. In this particular instance, there's no such obligation, or at least it is not specifically thought of that one would need a particular role or a particular individual to fulfill this particular role. But of course, it would be a matter for each and every manufacturer of connected products or related services to ensure that they are apt and adequately set up to live by their obligations. In terms of the second question, we are also foreseeing and expecting a number of standard contractual clauses to be released also in tandem with this with the Data Act, which would allow for less maneuvering in terms of negotiation. Always bearing in mind that as is, there already are those obligations which I highlighted earlier for fair terms and the presumptions as to what constitutes an unfair term where there is an imbalance of negotiating power between the parties.
Thank you, very clear.
Thank you for that. Would there be any other questions? We're reaching our 1 hour mark. So yes, Dr. Protelli.
Good morning. I have a question. I've been dealing with the Digital Rights Directive under the Consumer Law Framework. Do we foresee any kind of fit? Because there's obviously going to be a conflict between the rights of consumers under that and the rights and obligations of service providers to be providing this information to each other, exchanging information. And I was, wondering at what point there would be an issue in the interoperability between that framework and this one. Maybe Paul, maybe, I don't know.
Ms. Caduti, maybe?
I'm not sure I have understood the question clearly, but when we tabled the proposal, of course, we also considered, as usual, all the other initiatives, both in terms of policies and legislation, and we build the proposal in a way that we avoid conflicts between, for example, what we put in the Data Act proposal, what other colleagues that work in the consumer protection legislation are doing, or this is like a general approach that all the new legislative policy measures of the Commission have to ensure coherence with what happens in all the other sectors, both from the point of view of policy and legislation. So if any conflict will ever arise after the Data Act becomes a regulation, and we hope so, but then it's in the future, we don't know, we hope not, but in our intention and in our work of designing the new piece of legislation, we were very careful in making sure that those kind of conflicts do not arise, and we keep into consideration the work that colleagues in other DGs, of course, in other fields are doing, and we try to come up with a proposal that is coherent and complementary to the rest of the legislation that the Commission is proposing. And then because I mean, we don't have to create conflicts, of course.
Thank you very much for your answer, Dr. Caduti. We've reached our 1 hour mark. Would there be any last questions or comments from our audience? If not, okay, thank you everyone for joining our webinar today, and a special thanks goes to all of our speakers for their time and for accepting our invitation. Thank you and good day.
Thank you.
Thank you.